Welcome, everyone. I really appreciate you joining us here for the contracts portion of your project management training. It's a tough topic, tough time of the day, so I welcome comments, questions at any time. Please interject if you're curious about something, and we'll get through this. Hitting on the high points so that so that's beneficial to you, and you'll find that I've designed the slideshow, which you should have been sent the slides, as a reference material so that you can go back, look at certain clauses, and have guidance within this document. That being said, it does make, admittedly, it makes for a little bit of an unwieldy presentation in terms of looking at slides, and probably violates every informal rule of how to make a good PowerPoint presentation. But that is my purpose and why there's so much information in the slides. So let's get to it. As Carla mentioned, we do have some pretty sensitive information, how we approach contracts, our higher risk items, how we handle those. So please keep this internal. The purpose, when I'm taking your valuable time, I want to explicitly point out what we're doing, why you're here. I'm going to give you a short overview on contracts, why they're important for our business, and most importantly, things that you need to consider when a contract comes in or you're dealing with one. We also have I won't call it a new contract review process because it's been nearly a year since we've implemented it, but we do have a new contract management process, which I'm excited about. And we'll tell you all about that when we get to it, latter half of the presentation. And I want to provide all that with making sure that no one falls asleep in the sand. So again, I love the interaction. If you have questions, please don't be bashful and let me know, because it is a lot of material. All right, the agenda, give you just a quick introduction of the legal department. We'll go over the basics. We will spend a considerable amount of time on the deal breaker contract provisions. Essentially, those are the ones highest risk we really need to pay attention to. And almost without exception, when I have litigation to deal with in the company, it is usually touching on one or more of the deal breaker clauses. And then, of course, I will go through the new review process. So first and foremost, Karen Guest is our general counsel. Karen mainly handles the mergers and acquisitions work. We are obviously expanding as a company, as most of you know, and there's a considerable amount of legal work that goes along with getting those mergers, acquisitions, things like that handled. And so Karen, although she handles many things, her prime area that she handles is mergers and acquisitions. So in the event that you do have a contract issue, contract question, feel free to reach out to me, as that is definitely not the only thing I do at the company, but it is something I do handle quite often. So that's our two-person legal department. We're going to hit the contract basics, like I said, deal breaker, and then the new review process. So the first thing I want to touch on is to really dispel a myth. It's not self-serving. I'm shooting myself in the foot as an attorney, but especially as you get more familiar with the contracts that we see over and over again, you don't need a law degree to review a contract. Thankfully, my clientele, engineers and the like, are very smart people, and it really, a lot of it's plain English. Where my help can come in is providing context and, really helping you with what's a theoretical risk and what's a practical risk that we need to be considering, and just a history of how those things are litigated and whether it matters or not. So dispel that right away. Hopefully with this training, I also have a couple other trainings in the works, more advanced, on contracts, along with my contracts reference site. The object is to provide you all with enough training that you feel comfortable doing your initial passes at these contracts per our process. All right. So let's get in quickly. Most of you all know what a contract is, but it really is a promise to do something and getting something in return. Legalese, it's a meeting of the minds. And two of the first things you learn in law school is about the offer, someone offering you something of value and you accepting it. And you need to have both those things to form a contract. The consideration is the value. It cannot be a contract without consideration. In the event that we agree to do something, if I have to get something in return, or it's not a contract. So that's what I get in return or give up that's consideration. Signed by both parties, it seems self-evident, but we do continue to have problems with contracts that are not signed, or we recognize they're not signed until either the work's done or we run into an issue. I'll touch on that a little bit more, but we need those signed. It's interesting if they're things are on a napkin, that can be an enforceable contract, and verbal contracts can be enforceable. So we'll get into that a little bit. So those are express contracts and implied contracts. What an implied contract is in the event the two parties just forget to write things down or don't think it's important. What will happen if there's a dispute is a court would look at the actions of the parties, and if they acted as if a contract was in place, then the court will find what's called an implied contract. And they'll look to any documentation surrounding the circumstances, emails, look at what the parties have done. That's called the course of dealing between the parties, how they reacted to each other. In red, I have don't do it because it causes all sorts of problems with what do we really agree to, what are we on the hook for, how much should we be paid for it. So we've had problems, as I've said, with not having signed contracts or written contracts. Inevitably, it results in a collection issue. I'm just going to be upfront about that. We have quite a few projects where we don't have a contract and have had difficulty collecting our money on those. So very problematic lately. Why does any of it matter? It matters because it clarifies, there's a lot of non-legal things in contracts, as you well know. And when we go through the process of reviewing, there's a lot of things that I don't look at that are based on, the business aspect. The scope of work, for instance. Is the scope identifying exactly what we're going to be doing? We're going to touch on some hot button issues later on with scope creep and arguments from clients that we knew or should have known that certain tasks fell within our scope. Those are items that, from a business standpoint, need to be reviewed by the business folks and be aware of them. And it comes down to, obviously, what are we doing? How are we doing it? And when are we going to do it? And it really sets forth the expectations and really a process in the event something goes wrong. Really what it comes down to is it's an agreement that's enforceable in court. That's the difference between, a promise that I may make offhandedly to someone throughout the day with a formal contract. There is the expectation that we can enforce it. Something that's important I want to call out as we grow as a company, a lot of the practical issues that I face are the leverage and strength of the parties. Who's bigger, who's willing, who has, other contractors that are lined up to do the work. And so leverage, it comes up quite a bit in negotiating contracts. And it's very important for us, especially if we think that it's a new client, there's a lot of work there. We obviously want to be practical in negotiating the contract, but depending on that, the volume of work, we need to pay attention to what we will agree to take on in terms of risk and what we won't. And as we get larger and larger as a company, I've found that we're getting a a larger or more important seat at the table in negotiations. And so don't think, if you've heard in the past that, is our policy not to change our standard terms and conditions. I hear that all the time. That's just simply not true. So it is a reflection of the business relationship and how we're viewed in the marketplace. You'll hear me use the term commercially reasonable because it's basically that term is used to identify those promises that each company makes that have been determined to be pretty reasonable given our market and what the parties are expected to do. So that's why it's important, and contracts matter for us. Why does it really matter, though? What's the nitty-gritty? Legal reasons, obviously, but there's regulations that we need to follow. Business reasons, we lock down contracts so that we can look out ahead of us to see what our expectations in terms of work that we're going to do that we have under contract. And so it really helps us to plan out into the future, allocate resources accordingly, and headcount. If we have signed up to a number of contracts, maybe in one area, maybe one team, one region. So it helps us predict to a certain extent our business moves based on the contract reporting that we do and that I take into account. So that's why it matters. Obviously, a risk mitigation. What is in these, the language in the contract matters. It does. And usually a dispute starts with someone pointing to a provision in a contract and it going from there. I will tell you that the vast majority of issues that come up do not get litigated. There's no argument in front of a judge as to who's right in the contract. But based on what the contract says, it really provides strength or weakness based on our position in trying to just get it worked out. And allows us to point to certainty as opposed to the unknown of what we're supposed to do and when we're going to get paid. So what is my job? I will tell you, and I make this a point to tell groups when I'm training on contracts, that my role as counsel is to help get your deal done with the least amount of pain as possible while not giving up the ship on every contract provision that's out there. I absolutely consider it a failure on my part if we have to walk away from a contract if there's some negotiating room. So I am a very pro-business first attorney in-house and recognize that we don't want to be walking away from too many contracts simply because some of the language can't be tweaked. Now, of course, there's exceptions to that depending on what's being asked of us and the risk involved. But, my role is to advise on those risks. I do not make the decision for you. So I do get quite a bit of correspondence from folks saying, is it okay if I do this, if I take on the risk? It's okay if we discuss it, we discuss the risks involved, and we make a good business decision based on the risks that we see. And that's the best we can do because we'll never sign up to a contract with no risk. It just doesn't happen that way. So my job is to be in the trenches with you, helping you out, talking to counsel if I need to negotiate terms and conditions so that we get the job and we get the money in. So I don't mandate a decision-making process on contracts unless what we're agreeing to is illegal, and that happens essentially never. So that's our role. We don't approve contracts. I'll provide an assessment, and I really try to provide a practical assessment. I'm not going to hold up a contract because of theoretical 1 in a million risk, even if it's a rather large risk. So it just depends, and I really want to convey that here to help, not say no, because no, quite frankly, sucks when we're talking about getting business. So with that, really the focus of this Contracts 1 training here is to go over in some detail what the deal breaker contract provisions are. deal breaker is a bit of a misnomer because if a deal breaker clause reads poorly for us, that term could be read as then we'll walk away. It really is the deal breakers are ones that we really need to pay attention to that are prevalent pretty much in every contract, and therefore we need to focus on the language in those provisions so that we're aware. The deal breaker provisions contain the most risk, okay, and the most potential liability down the road, because that liability is not going to come out within 2 weeks of signing the contract. It usually is going to be a couple, 2-3 years down the road when something hits the fan and everyone goes back and looks at what's in the file. Okay. Now, are they the only provisions we need to worry about? No, not necessarily, because lawyers insert provisions in contracts based on new developments in the law or perceived edge in the market that they think they can corner with certain language. So it's not the only things we really need to pay attention to, but they are the ones that I would start with. And as you go through your training and become more familiar with the contracts that you see or have seen, you're going to come across clauses that you haven't seen before and that don't make sense to you. And in those instances, those are the ideal candidates that you want to push up and ask questions about. And like I said here's in the slide, ask yourself, have you seen it before? And you will find that there's consistency in the types of things that are in these contracts in the industry that we're in. It's just a matter of how they're worded. And lawyers are lawyers. They'll try to be tricky about things sometimes. So you should always assume that it's there for a reason. It's not necessarily set up to be fair, but sometimes it doesn't matter. But we'll talk about that here in more detail, so to provide you guidance so that makes sense. All right. The 5 that we start off with, the ones that we really, on every contract, these are the first ones that I would look at. They just jump out at me at this point. The first one obviously is indemnity, and that's essentially allocation of risk for wrongdoing. If something wrong happens on a project, who is going to cover that loss potentially? Who's going to defend that loss potentially? And does and to what extent our professional liability insurance cover it? We'll get at that in more detail, hopefully not ad nauseum, but we'll dive into indemnity. That is the big way. That's the big one. All right. Payment and pricing terms. Goes without saying, we need to read them. It's become less and less. The trend is I'm seeing less and less shenanigans with the payment terms. Really, it's paid if paid, paid when paid. We'll talk about that, and we really don't have too much flexibility on those, but at the same time need to read them because you never know what's inserted in the payment pricing terms, and it really matters where we stand in the contractual line. And what I mean by that is, do we have the contract with the owner directly? Not usually. We usually have a contract with an architect or another party that's in between us and the owner. And how do those payment terms match what the architect, for instance, has with the owner? Because I look to my goal is to balance the playing field if we're in a sub position. It's not commercially reasonable for us to not have less risk than the party upstream in the contract than us. But at the same time, and I see it a lot, we shouldn't be pushed down more risk than the owner has with the architect. That's, we want to stand on equal playing field with our business partners, and that's the goal that I try to get us to when we're negotiating contracts. Design rights, instruments of service. This was more of a hot button issue than it has been lately, although it's still always relevant. And we'll dig into that more, but it comes down to who's getting our designs and work at the end of the project, and more importantly, what can they do with them? And does that entail problems for us? in a damages limitation of liability. We'll talk about the different types of damages, what some of, have a pucker factor to them and others that are pretty standard, or what are called direct damages. And then we'll get to certs, representation, and warranties. Really, that's relevant to our professional liability coverage. But it's pretty straightforward how we want to handle those theoretically and how we have to handle them practically. There's a bit of a distinction in that, much to my chagrin, but at least I want to inform you about the practical reality that I'm seeing every day. All right. All right. So I know it's, again, hard part of the day. Contract's not the most important, most interesting topic. So we're going to go into a lot of detail here. Again, this is set up to be a reference. Please stop me if you have questions. And you're not, the goal is not for you to read every word that I have here. It's to highlight the principles, but yet have some examples that you can refer back to so that when you're comparing language, it clicks, okay? So at this point, before we kind of do a deep dive into each of the deal breaker clauses, are there any questions, or are there any areas or specific contract items that you'd like me to cover or are seeing? Anything is okay at this point. I just want to open it up for any questions.
There was a question in the excuse me, in the chat. What about email confirmation of a contract?
And this is Rich Fedvik. I asked that question. Can you hear me?
Yes, I can hear you, Rich. That is
okay,
that's a fantastic question, and I'm gonna address it directly here in about 2 minutes, 2-3 minutes. So that's a perfect example of a great question, because I want to make sure I can answer as many questions as I can. I can't hit everything, but to the extent we have folks that are facing something, now or recently that they need answered, by all means, throw it out there, no matter where I'm at in the training. So, Rich, I will answer that question directly and provide my reasoning behind it, but we'll get there, I promise. All right. All right, let's jump in. Indemnity. All right. What essentially indemnity in layman's terms is I agree to take on risk for you. Okay. And essentially that means if I'm doing work for you and my people or my subs screw it up and you're sued for my wrongdoing, then I'm going to indemnify you for that wrongdoing. Because your people didn't cause it, my people caused it, but you're getting sued because of the issue, then we'll step into your shoes and indemnify you for those issues. In a nutshell, that's what it means, okay? It's a contractual mechanism to take over a client's potential or actual legal liabilities. You'll see it in every single contract you come across. It's worded differently very often, but again, I've given you some examples here. Don't feel like you need, again, I don't want to beat it too much to death, but this is a very wordy slide. You're going to see some more, but these are just good examples for reference purposes. All right, so the first one on this slide, slide 12 here, example of a bad indemnity clause. And, I'm not trying to hide the ball, so what I've done is italicize some of the language there that's a bit problematic or at least needs to be addressed. Okay, so next slide, we're going to talk about the problems. I could leave it open and have people tell me what problems they see, but I think everyone would start typing emails and I'd lose everyone. So I'm just going to cut to the chase and talk to you about what the problems are, in particular indemnity clauses. And I've picked these examples because they are representative of typical indemnity clauses. All right. So many of you have probably heard this, but I need to explain. Defend. The duty to defend is not covered by professional liability insurance. And what does that mean? What that means is if a lawsuit is filed against our client and there are sections of that lawsuit that make allegations both against our client as well as us, if we agree to defend them, that's an upfront requirement or duty on our part. And that would require us to hire lawyers to defend the litigation. Essentially, the client would just send us the litigation and say, handle it. Okay. And the reason why it's not covered by professional liability insurance, when you think about it, is it's obvious because it's contractually assumed liability. An insurance company needs to insure known risk. And it's not a known risk if we're out agreeing to defend someone else, from a lawsuit that may or may not have any validity to it. Okay. And so there's a distinct, bottom line, you want to cross that out. The clients are used to seeing it. Some still argue about it. And I wanted to distinguish the duty to defend between our indemnity obligations, because what I usually tell folks is, look, if in fact we're found to be negligent, then our insurance, our professional liability insurance, is going to come back at the end and make you whole. And that includes for defense costs. The difference and distinction, and why we can't agree to the duty to defend up front, is that it's money out of our pocket, $1 from the get-go, before there's any finding whatsoever that we've done anything wrong. And so that's the distinction. And so when I explain to folks, look, you're not going to be, if we're negligent, then you're going to be made whole, but we're not covered for that portion of the litigation where we don't know yet. And that's where a lot of cost is incurred. So we want to strike that. And I'm sure many of you are already aware of that, but that's some of the reasoning why and the distinction made between indemnity obligations after a finding of liability or wrongdoing and defend obligations before. Before is no good. So the duty to defend, we want to strike. Our indemnity obligations take care of those costs if we're found to be negligent. All right. We want to, all means all, right? And so they're trying to be as expansive as possible. Really don't want to see all, because that's everything under the sun. Everything, including but not limited to attorney's fees, costs, and expenses. You can see essentially what I'm trying to portray or convey in this slide is that it's very open-ended and wide. Okay. Another thing, in the section 3 here, breach of any of the provisions of this contract, whether the claims are caused in whole or in part by any negligence or any act of omission of seller. So what that is saying, and this is something that is a lot of these companies, clients will want us to indemnify them for their own negligence. That is not commercially reasonable in any realm. Why would we cover you for your own wrongdoing? So that's an example of something we see often that we don't want to agree to. And again, the bottom portion of that, regardless of whether those acts or omissions were caused by the indemnities, which are the folks that we're indemnifying. So that's an example of an indemnity clause that's awful. Okay. So this is better. All right. And this is something that you can take and use and compare. And our goal is it is okay for us to indemnify other parties for our own negligence. However, it needs to be into proportion of our negligence, because without getting into it too much, but it explains why this matters and why the language is in here and talks about a comparative basis of fault. When a lawsuit is filed, the plaintiff is going to take what's called a kitchen sink approach, and they're going to include everybody under the sun that was involved in the project, and they're going to sue everybody. Okay, if it in fact goes to trial, goes to a jury, what happens is the jury is given instructions and they're given a verdict form, and each of the companies that have been sued and are still involved in litigation, they're named on the verdict form. And then there's a space next to it where liability is judgment by percentage. So there'll be a percentage number by each company. Okay. And so why we want to call out that we'll indemnify for our negligence on a comparative basis of fault, what that's saying is that to the extent the jury finds I make 13% negligent, then we'll pay and indemnify 13% of the award, if there is one, right? If we're not careful about that, we can take on other people's liability and other parties' percentages of liability. So that's a kind of a real world example of why this actually matters. It's not just a mumbo jumbo type thing. And that last sentence you can see is something standard. We're not obligated to indemnify the client for their own negligence, and or the negligence of others. And I think that's pretty self-evident. So slide 14 here is an example of what I call a commercially reasonable indemnity clause. We back up, stand behind our work. We'll make you whole if we screw things up, but we're not going to go beyond that and take on liability that we shouldn't. So that's the gist of that slide and this example. Are there any questions about indemnity? Because it is a very important topic. All right. So I have a takeaway slide for each of these. You know, if there's you know, a small group of slides that I'd suggest, you know, you really highlight or, you know, pay attention to, it's these takeaway slides. I've really tried to distill all this information down to the nitty gritty with, you know, what I hope is practical advice on how to handle this stuff. So strike defend, because it's not covered by our insurance. Indemnification should go both ways. What that means is if I'm going to indemnify a party for our negligence, then they need to indemnify us for their negligence. I mean, that seems fair. The standard of care. When we talk about indemnity and what's the standard, what is everyone talking about? In our business, it's negligence, okay? You'll see where folks, you know, assert a breach of contract claim. Breach of contract's not covered by professional liability insurance because the insurance company is insuring us to perform to our standard of care, okay? And we're going to get into that, you know, the standard of ordinary care. What does that mean and how should it be worded? But essentially that our professional liability coverage is connected to the standard of care. And that's why even if in practical conversations on the ground, when someone talks about the standard of care, you see people's face twist up and they don't want to hear it and just take care of the problem. But it matters because of how it flows up and how we're taken care of by our insurance company. So you want to look for you know, recklessness, willful misconduct, errors and omissions. Now, we'll talk about this a little bit more later, but be on the lookout for, as I mentioned, the appropriate standard of care is negligence, all right? As opposed to contracts that say you're responsible for fixing every error and omission that happens on the project. That's a strict liability standard. And it's a strict liability standard because you're strictly liable for every single mistake that you made. Now, the standard of care, as you well know, most likely is not perfection. Because in larger projects, it's essentially impossible to meet that standard, and the law recognizes that. So be on the lookout for, you know, we're on the hook for fixing all errors and omissions. You want to limit the indemnification to what the part of the project that we control, and again, in proportion to our negligence and wrongdoing only. All right, a lot of these other points I've made already. Anytime the clause is talking about a list of costs, fees, or what, you know, the indemnification includes, you want to include recoverable by law there in quotes, because again, that ties into our insurance coverage, because if that's in the contract, then our insurance coverage will cover costs and attorney's fees that are recoverable by law. Okay, so it's three words that matter. Look out for broad, all-inclusive language, as in that example I previously gave. Any, all, none. And finally, again, ad nauseum, we don't want to indemnify another entity for its own negligence or wrongdoing. Now, the last two check marks are important because it's something that I see quite often. And a lot of the clauses will say they seem to protect us because they connect to negligence. But in getting that indemnification back, they'll only indemnify to the extent that they're solely negligent. Okay. Why that matters is that in my example that I talked about, if a lawsuit's filed in the verdict form, where the jury enters percentage amounts of a liability and therefore money, what never, ever, ever happens is that the jury puts 100% for one company and zeros for the other companies. I won't say it never happens, but I've never seen it in 20 years. So it's basically like a fake indemnity provision. So be on the lookout. And what that means from a conceptual standpoint, we could be a company, the company that we're indemnifying could be 99% negligent. And if we're 1%, that's not sole negligence. Therefore, we'd have to cover the whole claim. So that's a practical example of that word sole. Be on the lookout for it and why it really matters. All right. Questions on the takeaways? All right. Payment and pricing terms. You guys understand what that is. Here's an example again of a bad for your reference later on. And we're going to cover in the next slide here why it's not a good one. I see a lot of this, and I'm sure you all have experienced this, where payment is withheld until we do X, Y, and Z. And that's usually tied back to the contract. We see all the time a client they make it contingent upon receiving payment for the owner. All right. And then payment by the client of an invoice from MyBank does not constitute acceptance of our services. Why that's important is that if we never have acceptance of our services, there's never a point in time under the law where our work's been accepted, so that there's not a clear line where the statute of limitations starts running. And you will find that, if you haven't already, that we get a lot of pushback when we look for, when will acceptance either tell us you've accepted our work, or we're going to infer it by the language in our standard terms and conditions. But that's why they're saying it does not constitute acceptance. I make warrants. This is as good a place as any. We cannot warrant anything. We don't provide warranties. Okay, we're a professional services firm. Lawyers, doctors, they don't provide warranty on services. All right, we perform to the standard of care, and we don't provide a warranty as our standard course of business. Reason why? Again, that is contractually assumed liability that no insurance company wants to be on the hook for paying out warranty claims that the client has incurred by a contract, because it's not a known liability for the insurance company, right? So it makes sense. So when you see warranty language, your ears should perk up and zero in on that, and you want to refer back to this slide as to why it's a bad thing. The last sentence there about the prices and the lowest prices, I don't see that often. If you ever see that we're providing a warranty that the prices are the lowest, one, we can't ever track it. So we just simply can't sign up for that. I haven't seen it as much, but to the extent the client demands that it be in there, what I usually recommend is we add further qualifications to it for, the same work in the same location at the same time. And then, it's hard to come back at us and say, well, this isn't the lowest price. So just keep that in mind. It's rare, but it can be very problematic to a company that wants it in there and wants to audit us, 6 months down the road as to our pricing. This happens on larger projects, and it can happen on government contracts quite often. So be on the lookout. All right. This is a better example. I'm going to summarize why it is. And it's because we've, really gotten rid of the pay when paid or paid if paid. So regardless of whether the client pays the architect in full, these terms, we're going to get paid anyway. In the real world, this almost never happens, and I recognize that. But to the extent we can get folks to agree to separate our payment from getting paid by the owner, that's a big, huge win for us. And then the second paragraph outlines exactly what will happen if we don't receive payment. Again, interest provisions are not that realistic from a practical standpoint, but this is an example of a best case scenario, and it's instructive to compare with the worst case scenario of the previous slide. All right. Takeaways. Something I want to note here, and maybe it's getting in the weeds too much, but it's important. Obviously, they don't adequately protect us because our contract isn't with the owner most of the time. So if the owner decides not to pay the architect for whatever reason, maybe the architect screwed something up, then we can be left holding the bag, not getting payment. So those are the examples why it's no good. You want to, strike when we can. But if we're stuck with pay when paid or paid if paid, you want to push for the pay when paid versus paid if paid. And the reason why is that courts that have looked at this particular language, if it is pay when pay, then there's the legal presumption that we're going to get paid regardless. Whereas with the if, it's contingent. Okay, so the courts look at when and if very differently. Some of our clients understand that, some don't. But I want you all to understand that it does matter, and if we're pushed, if we can get paid when paid over paid if paid, it can really help us out when it comes to collection, and in fact has. We've been able to collect on at least 4 since I've been here because of that distinction in that one word. And yes, it really comes down to that. You also want to have a nice statement in there, if we can get it, that the client must make a good faith effort to collect on our behalf, because it is something that they need to show if stuff hits the fan, and they need to make sure they're following what they need to do on their contract. And if they haven't complied with trying to push for payment on our behalf, well, then they're in breach of the contract, and that helps us out. Price guarantees, it's obvious. We have to avoid those. We can't track them. It causes problems from an audit perspective. And I've given you some language there at the bottom that if we have to have it in there and you just can't negotiate it out, then you want to limit it as much as possible. And I've given you some language at the bottom of that slide to help out with that. Give you an example. All right. All right. That's a lot of information. And your eyes are probably crossed. I have a tendency to talk fast. So based on what's been presented so far, I welcome questions of any kind. We've got a couple more to get through, and then we'll get to some talk about the review process and finish up here. But I'll open it up for any questions at this point.
I have a quick question. This is
Sure.
Carrie in medical equipment. So we put together our proposals, and a lot of our proposals have the terms and conditions at the end of the proposal. And then the AIA contract might come in. They may have signed our proposal. We might sign their contract. What if those two don't jive? Is it the contract, I suppose, the architect's contract that we're bound to, and not our terms and conditions that were signed in our proposal?
So that's a great question. So, and I'm glad you raised it, because it's something that it does happen. Is we have standard terms and conditions. Actually, the Contracts 2 training that you'll be getting actually goes through our standard terms and conditions, which are in the process of being revised right now. And it plays out like this. Usually the contract will dictate the order, what's called the order of precedence in the contracts, and usually the client's pretty careful about identifying which contract controls. And what I normally see is the prime contract controls, so the architect's contract with the owner, as applicable, flows down to us, which largely then our risks are the same as the architects. One thing I would mention is you want to make sure that it goes both ways. So not only do we have the obligations that the architect has to the client, but we have the benefits of, taking action similar to the architect against the client in the event that that's available. So it's usually handled in the contract. If it's not, the other thing I see is that they'll cross off our standard terms and conditions. If it doesn't identify the order of precedence in the contract, our terms and conditions aren't crossed off, and there's no other language indicating which set of T's and C's controls, then to the extent you have an ambiguity, it is construed against the drafter of the contract. So in the event we're forced, like a prime agreement is forced down our throat, but we have conflicting terms and conditions, and those terms and conditions conflict with the prime, then we'd say, well, we have conflicting conditions on this one. You are the drafter of the contract, so the obligation, the interpretation that's most advantageous to us controls. Okay, so that's the legal answer to the question. The practical answer to the question is it almost always is identified who takes which terms take precedent. And the other thing I want to mention and why it's a good question is that many times our standard terms and conditions will be accepted, which is a great thing. But then what happens is we get an invoice or some other documentation from the client, and they attach their standard terms and conditions, or it's part of their invoice. We need to be careful with that. I know you guys have, much bigger fish to fry than me looking at invoices and the T's and C's associated with those. But how I handle that in the standard terms and conditions is, ours control, and to the extent anything else comes afterward, ignore them. They have no effect, legal effect whatsoever. Okay? Does that answer your question?
Yes, thank you.
Okay. All right. Anybody else? Good question. All right. We'll dive back in. All right. Instruments of service, our designs. The first thing I'm going to note before we get into is that it's obvious probably to you guys too, but from a practical negotiating standpoint, the minute we handle our deliverables over, to the extent we haven't been paid or there's anything in dispute, we're not going to get paid on it. That's just the practical reality and what I've seen. So to the extent that we haven't been paid or there's a dispute on a portion of our work, how we usually are able to work those out in a way that's beneficial to IMEG is to indicate, looks like you have an issue with some of the work. So we're either going to figure it out or we're going to hold up our deliverable. And that usually gets the problem solved pretty quickly. Sometimes that's not practical. I totally understand it, but it's something I want to point out up front with instruments of service. And to summarize, the bad instruments of service clause is where we give ownership over to the client completely, and they get to do whatever they want with those designs. All right, even using those designs for another project that was not contemplated by the design. Something goes wrong because they've used plans that are very custom for one set of circumstances, but maybe they wanted to save money on design costs for a project that's very similar down the road, but it's not the same, and things go wrong. Depending on the wording in the contract, if we're not indemnified for that action, or we don't specify that our instruments of service and deliverables are for use on that project only, we can be opened up to that liability. I have seen it happen. So that's a summary of a bad instruments of service clause, okay? How to handle, this highlights kind of works made for hire. When you see that in quotes, there's a very important reason that that's included. That works made for hire is a term used in the patent arena and in patent law. intellectual property. And if it's a work made for hire, there's all sorts of protections that go along with it and how it can be used and what type of license is inherent in that work. So it's not altogether a bad thing to see it, but just know that those are, cover words for you're giving us this work and we're going to have a heck of a lot of right to do what we want with it. So just be aware of that. And really what I give you an example here of why this is a better, again, for reference purposes only, you can compare them and see why it's better, mainly because we retain the rights, which is always good. And we give a unlimited license to use the instruments for the purpose directly related to the performance of work under this project. And if they decide to breach that and go ahead and use it for something else, they expressly agree to indemnify and hold IMEG harmless against anything that happens. All right, so that's the ideal, maybe not practical, but ideal instruments of service clause for educational purposes of what we're really, the ideal situation we're trying to get to, okay? Takeaways, and apologies for the font size. I need a magnifying glass and I typed the friggin' thing. So 2 courses of action. It's really 3 courses of action, because one is the practical reality that I think is good if we can get it. So the preferable option is obvious. We want to retain ownership of our documents. We provide them a license and we specify it's for this project only. And oh, by the way, if you use it for anything else and something happens, you indemnify us, defend us, and basically take on that lawsuit because you've misused our stuff. The other option is, and what I see 99% of the time, is the owner wants to acquire ownership of our docs. In that case, it is usually, I don't want to say usually, but it's not uncommon for the owner to recognize that we need assurances that, yeah, we'll give you ownership, but you need to use it for this project and indemnify us for other use. Now, if the owner, or a client rather, it's usually the owner. If they balk at indemnifying us for anything, then really what you want to do, and I advise, is get something in there that says this is for this project only. So even if they don't indemnify us for other use, it's clear from the contract that the parties contemplated that what we did was custom for that project, so that, some idiot uses that for, another project. I have a pretty strong argument that the expectations of the parties were such that we're not on the hook if you took our stuff when you said you wouldn't use it for another project. I put that as plainly as I can. So what you might want to write on this is just make sure you get assurances for this project only. Okay? Again, example of ideal language at the bottom for your reference. I, acknowledge it's ideal, but it's also instructive of what we'd really like to see. Okay. This is a pretty quick one, but still very important. You'll notice IMEG standard terms and conditions. This is something it's interesting. Some versions that are out there have a dollar amount of 10,000 in there, and then some others are blank. Either way, the 10,000 is an example only. The better version is the one that has it blank. If you can get a client to agree to limit our liability, you should do it. That's a huge win for us. And the argument that you make is, usually we have a small piece of the pie overall. So it's not commercially reasonable for us to take on liability of the entire project. So with that in mind, sometimes they will agree to limit it to our fees. This is how much we're getting paid for this work. Let's agree to limit our liability if things go wrong to our fee. That's a huge, huge win for us to get that. So I want to make that clear that it's, try to fill it in on our standard terms and conditions with a number that you think is reasonable. I know that there's a document floating around out there. I'll try to get it up on my contract site that is from Paul Van Dyne that kind of gives you an idea of what you should be thinking about in terms of that number. But again, try for it, and we do get it, and it's a great thing to have in our back pocket if things go wrong. Also, you need to know the distinction between direct damages and what are called indirect damages. Direct damages are what you would think of if we breached the standard of care. We're negligent. We installed the wrong size vents in a high rise, and we failed the fire testing capacity test, and therefore have to rip it out and put all new in. Okay. The cost of removal and the cost of putting that back in, those are direct damages that have resulted and is connected directly with our work, our negligence, where we breach the standard of care. So they're directly connected, therefore they're called direct damages. Where we really can get in trouble, and what makes me worry about things on these sometimes, is the indirect damages, and those are either consequential damages or liquidated damages. Why they're called indirect is because they don't directly relate to the problem itself. It's not the vent, the correct vent, and ripping it out and reinstalling. It is, for example, delay. The certificate of occupancy is delayed by 10 days because we did that. That's what's called, and then as a result, there's consequential damages. That's an indirect damage of that breach. That can get pricey. Usually what we see is a waiver by both parties in seeking consequential damages, because both parties understand that those numbers can get real high. On the worry scale, the one I worry about the most is liquidated damages. Liquidated damages are simply punishment damages, and usually they're also tied to delay. Okay, so if we're determined to be solely the reason a project is held up and there is a $20,000 a day liquidated damages clause in the contract, that is bad news and can get very, very, very high, and it will be litigated because we're gonna try to show that there were other entities that did something that caused a delay. So be on the lookout for consequential or liquidated. The ideal situation is have a waiver or just exclude them. What I will tell you is that the rule is, if it's not specifically called out, then the law assumes that there are consequentials available, not liquidated damages. If you want to have liquidated damages in a contract, it has to be specifically outlined in a contract. However, consequential damages, if the contract doesn't mention them, then it's free game. Now that depends on the jurisdiction, but for purposes of this training, you should assume that that it's game on for consequentials unless they're specifically excluded. Okay. All right. Here's an example of a bad limitations of liability clause. And here are the problems with it. So what this is basically saying is that, and this is quite common actually, that we're not going to limit damages to your insurance coverage. IMEG has a very high limit, which is a good thing, but we also have a very high deductible, which is a bad thing. And this is saying that it doesn't matter what insurance coverage we have. Damages are damages, and you're going to be on the hook for the damages that you cause. So that's something to keep an eye out. And the solely responsible piece is exactly what it means, is that all that the duty to repay and the hurt falls directly on us. Okay. This is better, essentially, from our standard terms and conditions. Again, be on the lookout for training. We're going to go through our standard terms and conditions. I'm going to try to explain the ins and outs of those so you feel very comfortable with them. But this is better, and again, use that as a reference point. Want to point out make sure you fill in the amount in that contract and don't use 10,000. It's too little. All right. The paragraph 2 is a really good explanation and kind of gives you context as to how and why consequential damages are a bad thing and why this language really addresses that risk quite well. Okay. All right, takeaways, I think we've covered quite a bit. You want to try for that limit. You want to try to get in every contract, even if it's not using our standard terms and conditions, including a sentence, the same one from our terms and conditions in the contract, or negotiating that in, or just adding it in your first round. Nothing wrong with it. And as I mentioned, if the damage, consequentials aren't talked about anywhere in the current contract, it's presumption that we are potentially liable. And we've covered the rest. Always want to cross out liquidated damages. If that's the first go around, you always cross it out. Okay, so you might want to write that there. Liquidated damages, just cross it out. And if you get pushed, the answer is IMEG looks at those as punishment damages, and we're willing to waive them against you. But it doesn't, it increases the risk for all parties involved, and it's not an insurable risk, and therefore it just increases costs across the board. That's the bottom line. All right, last one. This one also is relatively straightforward. Certs, reps, and warranties. Be very careful with this, because what we're signing up to do is to provide professional services pursuant to a standard of care that is standard in the industry. And if we agree to anything more than that, we're on our own to back it up. And if we provide a certification that goes beyond the standard of care, or a warranty that goes beyond the standard of care, it provides a cause of action, just meaning another way to sue us. So if we provide a warranty, we're opening the door for a breach of warranty clause. If we provide a certification that we shouldn't, it's breach of a certification. And it really opens up avenues that we otherwise wouldn't be faced with, just because we carefully didn't cross those out. Now, I usually, when we cross those out, there's a recognition as to why our insurance doesn't cover this. We are, trained, insured, and perform to the standard of care to our industry. And we take that very seriously, but we're not going to sign up for, everything under the sun to give you the assurances you need to the detriment of our ability to cover it. Okay, so that's an example of a bad one. Something I want to point out on this slide, I'm seeing more and more often, is language talking about the highest standards of professional and ethical competence. No one knows even what that is. And so how that plays out practically is that if we're sued, they'll find some person to get up on the witness stand and say, well, the highest standards are this, this, and this, and what this, and this is everything we didn't do. So be on the lookout for that. It's garbage language, should be taken out, because no one knows what that even means. Again, the yellow language basically also outlines a strict liability standard. It indicates if we screw anything up, we're going to restore it to the same condition as previous. All of this language keeps pointing to additional obligations that fall outside the standard of care. It doesn't mean we're going to do a bad job. It doesn't mean we're trying to avoid liability. It means that we are doing our work pursuant to how we're licensed, certified, and insured. All right, sole judgment. When you see that, you never want to leave IMEG to the sole judgment of a company, a client, any other party, because that really leaves us in the lurch with, if we agree to comply with someone's sole judgment, well, it means whatever they feel like doing. The highest degree of care possible, again, same thing. one thing too, I really want to mention, it's not formally in this slide here, is, and I'll get to it in just a second. Sorry, let's cover this first. This is better why, and this is an example of language that I see that you may see quite a bit, that you're asked to certify certain things. You can certify that you're licensed in a state. That's a fact that is provable and true. And so I have no problem with certifying something like that, mundane, that we know is true. But instead of certifying anything, you want to put into the best of my knowledge, information, and belief in general conformance with the plans, because we don't know everything is in strict conformance with the plans, and probably it isn't. And you know, tie everything to your professional opinion, and you're covered for that, you know. So paragraph 2 there is straight from our standard terms and conditions. I really like this because it makes clear that we're not going to sign up to, we're not going to be required or asked to sign any documents that, in a nutshell, exceeds our liability or obligation beyond the standard of care. All right. Getting to the takeaways, we've covered all of this. It's a good slide to highlight as a summary slide. The appropriate standard of care, I want to point this out. The language that I recommend that defines the standard of care is at the bottom of the slide. Okay, so if you're asked to include what is that, or what would you guys like to see, that's the standard of care. All right, consistent with the professional skill and care ordinarily provided by folks that are similar to us in similar industry. Okay, one thing that is I'm really seeing a lot, and there's a big movement to make design professionals to have a fiduciary duty to their client. That is a huge red flag. You definitely don't want to sign up as to being a fiduciary on a contract. Absolutely not covered. Because if you agree to have a fiduciary duty toward a client, then you're required by the law to put their interest ahead of yours, no matter what. And that means give them what they want and us not getting paid. So really be careful with the fiduciary duty type of language if you see that in a contract. Okay. All right. So wrapping up the the tiny type stuff, unless it's AIA, you don't want to default to the architect standard T's and C's. I say AIA is good, but there is AIA also look for many times you were sent a contract, they say it's AIA, but then they've changed and revised pretty much everything in the AIA contract such that it really doesn't provide us the equal playing field that the AIA contract is designed to create. Okay, and the way you can figure that out is there's what's called a revision report, and kind of goes with the licensing of the software. And so if you're unsure and get an AIA agreement sent over and you're unsure, it looks a little bit different, ask for that revision report, because then, and it's generated when those terms and conditions, because they are copyrighted, trademarked, whenever those are changed, it generates that report. So you want to ask for that report because it will show you exactly what's been added, taken away, or changed. Okay. Get copies of all contracts. This has been an ongoing problem. People are busy. Usually the contract is one of the last things that gets taken care of for obvious reasons. Everyone's really busy working on the the stuff that gets us paid on the project. I understand that, but you want to follow up and make sure that we get a signed copy. Then we're gonna have you upload that in Salesforce. Hopefully that reference is not brand new to you all, but we'll be covering that here just shortly. And then to the degree, and this I will tell you is probably the number one thing that has cost us money this past year, is if there's scope changes to what we agreed to, you have to get at least an acknowledgement. Okay, and the question came up early. Is an email okay? It's better than nothing. Sometimes a formal change order isn't realistic, and I understand that. But we need something in writing. If that's an email, where we say you've asked us to do this additional work, it costs this much. Please indicate whether we're correct or give us the authority to proceed. If you have an email back from them saying yes, we agree, then I can work with that. Okay. If they call you on the phone and say, yeah, go ahead and work on it, just say, I appreciate that. Could you send me a quick email? All right. If we rely on oral promises, it's going to become a collection issue, almost guaranteed. Almost guaranteed. All right. So just a practical tip. It's at the kind of a high level pain in the neck, and it's a hot issue right now with leadership. Based on some money we're having to flush. So just be aware of that on changes in work. Not going to spend too much time on this other than to say, if you get a cyber provision, that's something that you want to send to me or to Julie Anderson. The IT department and Julia doing a great job to button our our cybersecurity up and what we need to do, whether under federal contract or, commercial contracts. Things can get out of hand quickly. Some liability can come in, and then some notification requirements that can be timely, that can be very time intensive, super expensive for us. So just keep an eye out for cyber provisions. Again, warranties, run like heck from them. Look for standard of care end runs, which is language saying you'll fix everything. And we'll tell you when to do it. That's not the standard of care. Don't sign up for perfection. And then unique considerations for government contracts. A lot of my practice used to be focused on government contracts. I will tell you that in terms of risk, in a contract coming back to haunt you, it's going to be most likely a federal government contract. It is very serious to sign a federal government contract and misrepresent something to the government. It's called a False Claims Act violation. They're extremely expensive. The penalties are enormous and could subject you to criminal liability if you misrepresent something. So, bottom line, if you have concerns about a government contract, reach out to me. We'll walk through it together. But I'm definitely not blowing smoke when it comes to government contracts. They can nip you. So if you have insurance questions, go ahead and reach out to Deb Swift. I know they have a process set up. Deb's very fast. We have a great broker, a new insurance broker that helps us out quite a bit. Been really happy with their help. I've been getting requests for, I do want to mention this, getting requests for project-specific policies. That is possible, but what I'll tell you is they're extremely expensive, about $50,000 to $75,000 annually. But keep in mind that you have to have that coverage in place for the full term of the statute of limitations, because it's a claims-based policy. Okay, so it depends on when the claim's made. You have the insurance coverage, and the insurance coverage has to be in place at the time the claim's made. And if the claim can be made up to 10 years after the end of the project, then you need to have that insurance in place, project-specific insurance in place up to the end. So, $50,000 to $80,000 over 14 years, that's very, very expensive consideration. So we look. When that request comes in, I'll usually call the person, and usually it's a municipal contract, but we'll work together to try to figure out, which usually entails me calling the government contracting officer and asking them, do they really need this, and are they sure they know what they're asking for, and do they realize how much we're going to quote for something like that. So just a heads up on that. All right. Very briefly, you guys have been great. I appreciate your time and listening to this. I'm going to stop before we get to this to see if anyone has any questions on what we've covered, the deal breakers, or anything else that you may be facing right now. All right. The new contract management process, we needed some standardization. Each of the teams was basically handling it different. And how it was handled is basically contracts all over the place, in email, on folders, on the share drive, wherever. It's the review process is part of that. I essentially am the only person that reviews contracts for the company. And obviously, it's not conceivable for me to review every contract that comes in. That's why we do have a process in place, and that's why we're working on training as much as we can. The new CMS is live in Salesforce, and we really went with the Salesforce because, one, huge cost associated with CMS, commercial off the shelf that it would need to be customized, ridiculously expensive, and it involves our people learning a whole new system just for contracts, and we thought that was a terrible idea. So it's just an added tab on Salesforce that you all are familiar with, that user interface. It's very easy to add the contract to the account or the project. And then within that is a way to review or request a review by me if you have specific questions on the contract. So we will be sending those instructions out if you haven't seen them already, and they will also be posted on they already are posted on my contract reference site, which I'll touch on briefly here. But if you have questions about that, Deb Swift is a guru with Salesforce, and she's understands the CMS very well. So I'm going to summarize essentially the important points here, because you can really look at the particulars later. The initial review is at the project exec level to look for non-legal items first, so we know the who, what, where, when. You'd be surprised how often sometimes that's not reviewed, and we can get into some logistical nightmares. But and then review the standard contract clauses, utilizing this training, have this slide presentation out. I promise you, if you get through 2 or 3 of these, it's going to get familiar for you. And if you get to one where you're not sure about the language, that's when you move it up to your client executive next with your question. Usually the client executives have a lot of experience with contracts, so they can usually answer your question. And if not, the client executive elevates it to me. Just a quick tip, just a contracts reference folder for yourself, and that's just for examples. So if I give you feedback on a contract or provide some markup or give you a clause, some language to use, throw it in that one folder, like maybe on your desktop, and you'd be surprised how often the same issue keeps coming up, and it's just quicker. And really, the issues of first impression where we don't see them or haven't seen them are very rare. More contracts training is coming. I'm sure you're terribly excited about that. But again, it's going to give you what you need to know, and it's going to provide you with a resource that you can refer back to. One thing I do want to point out, and the last thing you probably want to hear about is another SharePoint site. But I really try to keep this up to date. The contract reference site. I post out there general legal issues, things that I'm seeing quite often. I try to give very practical language that you can use, very specific guidance. And it's really easy to just go in there and look to see if your question has been answered, or if there's some language you can use, or what it's used for by a lot of people is the reasoning as to why we're asking for certain things. I've really tried to get that out there so that if you receive pushback or someone doesn't understand why we're asking for the change, why we're asking for it from a very common sense point of view on that site. There's the link. An alert can be set up, so when I add to it, you get a ping for anything new. But checking in on it every couple weeks, I'd recommend it because there's a lot of information out there. All right. So again, the secondary review goes up to the client exec. Review your questions, and then the client exec will take the issue to me if they haven't seen it. And then usually how it comes in is, can you review the language in paragraph 12, for example, because I'm not sure I like how that looks. I'm happy to do that. If you have something urgent, please just give me a call. I travel quite a bit, but I ask that people text me. If they have an urgent issue, I'm going to work with you. I don't want to lose a project because, you know, I'm sitting in a conference or something like that. I'm going to, you know, I want to help you guys. I want to get the work in. I want to get the contract signed so you guys can do what you do. So please, you know, try to use me as a reference, you know, when you need to, you know, but follow the process if you can. And if you need it quickly, just let me know. All right. This is essentially when the client exec goes to legal. There's a sales review. Salesforce handles it. It's really a contracts tab. You add the contract, and one of the things you can select is having a legal review, and then you have to insert a reason why, what the question is specifically. And, you know, the reason why we went this direction is, as you can imagine, a new in-house counsel. Every contract under the sun was just kind of dumped in the email and sent over to me with, you know, a request. Can you take a look at this and let me know if you see problems? That's just not viable on, you know, 640-page contracts. As much as I'd like to provide that level of service, I, you know, just can't. So I want to do the best I can and allocate my time to the hard issues. Again, right now it's about 2 days, maybe 1 day. But it just depends on current volume. Again, call me or text me on my cell phone if you have an issue. All right. I will tell you, if you can get on the phone and go through the contract, we probably can get it done really quickly. All right. This is the summary. It's easy. Again, my site, we update it. Use this slideshow to the extent you need it. Don't let it get out, because it does kind of identify our priorities and how we want to negotiate and what matters to us. So if you're asked for how does IMEG handle contracts, probably don't want to give this one out. All right. Anyone have questions or comments? I know it's not the most exciting topic. I appreciate your attention. Everyone's been great to work with. I enjoy getting the questions. So anything from anyone right now? All right, guys, if you have follow-up questions, feel free to email me or give me a call. Again, I appreciate your time. We've made a lot of progress. I'm impressed with how the engineers have looked at these things and the people in the work for us. So you've been really helpful, and thanks for your time today.